We're ready, you guys. Good afternoon. Today is March 20th. This is the hearing of the House Judiciary Committee. We have two bills today. The first bill we're going to hear is HB 1605 with Delegate Griffith. We're flipping them. Okay, the first bill we're going to hear is 1616 with Delegate Rogers. Yes, please.
Good afternoon, Chair Davis and members of the hardest working committee in the General Assembly, the Judiciary Committee. And I think I'm setting a world record by being here twice in one session. But for the record, I'm Delegate Mike Rogers, representing Legislative District 32, and I am here to testify in favor of House Bill 1616, Mutual Insurance Holding Companies Conversion to Mutual Insurers. So I respectfully request a favorable report of House Bill 1616. In 2000, Maryland passed House Bill 119, Mutual Insurance Holding Companies Act, to allow mutual insurance companies to reorganize into a new hybrid corporate structure that combines elements of both stock and mutual insurers. Under the legislation from 2000, a mutual insurance company can reorganize into a stock insurance company that is majority owned by a mutual insurance holding company. The policyholders of the converted stock insurer become members of the mutual insurance holding company and therefore retain indirect control of the converted insurer. This legislation was intended to provide a means for a mutual insurance company to address certain disadvantages of a mutual insurance company organizational form, like accessing outside capital stock by selling some of the stock insurers' insurance stock to outside investors or acquiring third-party companies without having to combine the two insurers, while still preserving policyholder ownership and control of the enterprise. Since then, only 4 companies have converted from a mutual insurance company into a mutual insurance company. The first company to reorganize was Baltimore Life Insurance Company. However, Baltimore Life has never used the mutual insurance holding company structure to raise outside capital or acquire other insurance companies. Baltimore Life would like the opportunity to return to their former status as a mutual insurer if needed in the future. However, under current law, there is no clear mechanism for Baltimore Life or any other mutual insurance holding company to return to the mutual insurance company structure. While mutual insurers may reorganize to become a stock insurer and establish a mutual insurance holding company, there are no provisions related to voluntarily unwinding such a reorganization and returning to the original mutual insurance company corporate structure. House Bill 1616 is a technical bill that appears complicated, but is really very simple. The bill adds a new section to Maryland law allowing mutual insurance holding companies that directly or indirectly own 100% of the capital stock of the stock insurer to convert back to a single mutual insurer. In essence, this provides converted mutual insurers with the ability to revert back to their original structure and direct 100% ownership by their policyholders if they have never sold any of their stock to outside investors. Under House Bill 1616, the process for reorganizing back to a mutual insurer mirrors the process and the safeguards that currently exist for mutual insurance companies that convert to a mutual insurance holding company structure. The companies must develop a plan of conversion which must be approved by a majority of the board of directors and approved by a vote of at least 3/4 of the members of the mutual insurance company. Moreover, the plan of conversion must be reviewed and approved by the Maryland Insurance Commissioner. This bill also—
Delegate, can we wrap up?
Yes, this bill also authorizes the Maryland Insurance Commissioner to adopt regulations to these reorganizations.
I'm sure there'll be questions. Next.
Good afternoon, Vice Chair Davis and members of the House Judiciary Committee. My name is Sarah Case Herron, and I represent the Baltimore Life Insurance Company, or Baltimore Life. I'm here in support of House Bill 1616, Mutual Insurance Holding Companies, Conversion to Mutual Insurers. Baltimore Life was founded in 1882 and has provided life insurance to 7 generations of Marylanders. We are also one of only a handful of insurance companies who've taken advantage of the ability to convert to a stock insurer and form a mutual insurance holding company. While Baltimore Life was grateful for the ability to convert to a mutual insurance holding company, we believe it would be a benefit to our company and others to have the flexibility to potentially revert back to our original form of a simple mutual insurer. House Bill 1616 would provide a clear statutory processes for businesses to reorganize back to their original mutual insurer form while maintaining the important safeguards in current law for any such reorganization. As Delegate Rogers mentioned, the bill would only apply to companies that have maintained 100% control over their capital stock, meaning that outside investors would not be negatively impacted by any proposed reorganization back to their original form. This bill also maintains the Maryland Insurance Administration's clear oversight and authority over this process and requires that any reversions be approved with clear majority votes. There's also no net fiscal impact to this bill. We believe that House Bill 1616 is a simple and sensible update to Maryland law and urge a favorable report. Brett Balser from Funk and Bolton Law is a subject matter expert and is here just for questions. So that concludes the testimony.
Thank you. Colleagues, questions? Delegate Cardin.
Thank you, Madam Chair. Thank you very much for coming. Delegate Rogers, you indicated that we were the hardest working, but are we also the best?
You're certainly the hardest working.
Fair enough. No, this is for your witness. Thank you very much. So what if you convert over like you have done, you sell 1% or one share or whatever, just one share, you can't revert back, right? But what if you buy that share back? Can you then, or does it have to always be 100% for 100% of the time?
I'll let Brett talk to that, but
Yeah, so I think the company would still be able to convert as long as they were able to buy back and maintain 100% at the time of
Okay.
converting to their original form.
And is there a reason, you just want the flexibility, you're not necessarily going to do this, and are you the only company right now that would be impacted by this legislation?
yes.
Got it.
And it is one where the original form of the mutual insurer is a simpler one. So there is like overhead obviously associated with the more elaborate structure of the mutual insurance holding company.
Sure, yeah, I think there are expenses that a company would incur having a two-company structure, and then
Yep.
Those would also ultimately be passed on to the policyholders of the company. So.
Great. Thank you. Thank you, Madam Chair.
Thank you, Madam Chair. How many companies would this law impact if it went through?
So there are currently 4 companies that have converted to a mutual insurance holding company structure. Of those, I believe that in their current form, only Baltimore Life would be eligible to return to its original form under this structure.
And one last question. So could this need have been addressed through regulatory guidance or a case-by-case solution?
No, we do not believe so.
Okay, thank you.
Delegate Taylor.
Thank you, Madam Chair. Actually, I believe the last question you asked was my question, is can you do it now by asking permission from the insurance commissioner?
No, currently the law actually provides, the existing law from 2000 provides that the mutual insurance holding company is only permitted to move in the other direction, meaning they're only permitted to convert to a full stock insurer. There's no mechanism under the law that would allow for this.
It would also give mutual insurance companies, they wanted to try it, and if it didn't work, then they'd be able to revert back.
Correct.
Do you know if there are any other industries that have that kind of provision where if you can try something and then kind of revert back?
I think that really it's the mutual insurance company is a very sort of unique form in that the members are really the stockholders of the company. And I think that it's difficult to analogize to maybe another company structure just because in this instance, the mutual insurance company's members are the policyholders.
Right.
So when they convert to the mutual insurance holding company system, their members still retain control, but it's sort of a hybrid structure. So
I get it. So your policyholders are your owners. So if you get permission from them, then you can go back to the more simple structure where you're only raising funds, you're only selling policies, you're only gaining revenue from the owners who are your policyholders.
That's correct.
Okay, I got it, thanks.
Okay, Delegate Phillips.
Thank you, Madam Chair. Practical question. This bill was cross-filed. Can you tell us the status of the cross-file?
So I actually believe that the cross-file might have just gotten out of rules today, but it was mostly just stuck in procedural pieces because of efforts to get drafting done in time. But it is, the cross-file, I think, is unlikely to move in the same posture as this one, so.
Okay.
Go ahead.
As a follow-up to that, is there something time-sensitive about the requested legislation?
I do believe there is, because right now, as Brett mentioned, while Baltimore Life has no current desire to necessarily reorganize back, there's no way to do so at the current time. So if they were to want to reorganize back to their original simpler form with obviously the lower overhead and expenses, they would not be able to do so absent, as we mentioned, this legislation, which I do want to state for the record, the Maryland Insurance Administration did review this legislation and had no issues with it. And if this doesn't pass, obviously this session, we'd be waiting till at least next year, followed by time for the Maryland Insurance Administration to do regulations before it would even be an option to revert back to their original form and have that simpler, lower overhead organization.
Thank you.
Thank you. Any further questions? All right, seeing none, thank you for being here. This ends the hearing for HB 1616. Thank you so much.
Thank you.
Thank you.
All right, we're going to call HB 1605. Delegate Griffin.
Thank you, Madam Chair. May I bring up my panel, please?
Yes, please.
All right. Thank you, Vice Chair Davis and members of the committee. I respectfully request, for the record, my name is Delegate Mike Griffith, and I respectfully request a favorable report on HB 1605, compensation for individuals erroneously convicted, county cost sharing repeal. This bill addresses a cost shift enacted through the fiscal year 2025 BRFA that requires counties to reimburse the state for 50% of wrongful conviction compensation awards, and restores the structure in which the state is fully responsible for these payments. In doing so, the bill helps ensure that individuals who have been wrongfully convicted can receive compensation through a consistent and state-administered process without disruption caused by the current funding structure. Under current law, the state determines eligibility through the Office of Administrative Hearings, the Board of Public Works approves the compensation, and the state defines both the amount and the scope of the awards. Counties have no role in prosecutions, appeals, or compensation decisions, yet they are required to fund half of the cost. This creates a fundamental mismatch. The state controls the process, but counties receive the bill. The impact of this policy is already being felt. Counties are receiving significant, unplanned fiscal obligations that arrive outside of their budget cycles and without any ability to anticipate or influence the outcome. In some cases, these costs include not only direct payments, but also multi-year benefits determined entirely by the state. This bill corrects that imbalance by aligning fiscal responsibility with decision-making authority. Alongside this change, the plaintiffs' bar and defense bar have requested that we submit amendments that would clarify that the bill applies retroactively to any compensation award made or payment issued on or after July 1st, 2025. And we view this as a friendly amendment, as it ensures that counties currently impacted by the cost shift receive immediate and appropriate relief, that the 4 cases currently underway are covered under this retroactive application. Counties support compensating individuals who've been wrongfully convicted. However, the state controls every aspect of the process. The responsibility to fund that compensation should rest with the state. By restoring this structure, The bill promotes a more efficient and streamlined process, helping ensure that those who have been wrongfully convicted receive their compensation in a timely manner. For these reasons, I respectfully request a favorable report on House Bill 1605. Thank you.
Thank you to the Vice Chair, members of the committee for having me. My name is Sarah Sample, here on behalf of the Maryland Association of Counties, and we are here in very enthusiastic support of House Bill 1605. We have a number of local representatives here that are going to talk about the specific challenges and impacts that have been felt by their jurisdictions. So I'm just going to sort of talk a little bit more about the broad statewide impact. I will say the sponsor did a wonderful job of explaining that this is something that is a state cost shift for something that we have no control over and no role in, and that these are costs that cannot be anticipated easily. They come in after our budget cycles, and the timing of them is also makes our budgeting a very volatile situation with how this is playing out. The one thing I want to point out, though, is that the state enacted this as a budget balancing mechanism last year, and it doesn't really have any meaningful effect when it comes to being able to plan for revenue that helps them balance their budget, because like we've already said, this is not something that they can count on in terms of revenue or anticipate or plan for ultimately. So it functions poorly from a budget balancing mechanism. It creates serious budget ramifications for local jurisdictions, particularly our smaller jurisdictions that you're going to hear from today. And there was no consideration of the policy ramifications that also came with this, and you are going to hear a little bit about that from the plaintiffs bar, which, it's important that they're here to, I think, point out some of the things that this has really created for them. So there are really big policy ramifications here. This body was not able to consider this last year, and they think that that is absolutely the appropriate way that something like this would need to be done. So we are very supportive of this correction and repealing this mechanism that was put in the budget last year, because again, it does not further justice, it does not balance the state budget, and it does serious harm to local jurisdictions in their budgeting process. Thank you so much. We urge a favorable report.
Hi, Madam Chair and distinguished members of the committee. Hi, my name is Bunky Luffman. I'm Director of Administration for Wycomico County. Unfortunately, we were the first county to be hit with a bill due to this. There was a settlement for approximately $573,000, and our county would be on the hook for $286,000 approximately. And under blueprint, a teacher's salary has to be $60,000. This is nearly 5 teacher salaries. And I could go through the budget on how many different other things that we could, allocate our resources to instead of this, which we believe is a state responsibility. Looking through the fiscal note with the bill, in 2024, administrative law judges issued 5 orders of compensation, which totaled $8.8 million. So we sort of, even though our bill's $286,000, which is a lot for a small jurisdiction like us, these could get very high very quickly. And you have to remember, we have some counties that have under 30,000 residents. We have 3 counties under 30,000. We're not one of them, but it hits our budget with 106,000 residents. I imagine if this hit Somerset, Kent, Garrett, and those smaller counties, this would be even more impactful on them. So, and again, it's unplanned. You can't really budget for it. So we would ask that you would keep that in consideration as well. And we urge a favorable report on this bill as well.
Good afternoon, Madam Chair and committee members. I'm Roscoe Leslie. I'm the county attorney for Worcester County. In fact, I am the entire legal department for Worcester County. I handle all the civil matters for the county, but I have no criminal matters that I handle directly. I also serve as the president of the county attorney affiliate for the Maryland Association of Counties. I'm here to support HB 1605, repealing cost sharing for erroneous convictions. If the goal of the current law is more accountability for erroneous convictions, making county governments 50% liable for compensation simply doesn't achieve anything. County governments, especially rural counties, have no levers to pull to prevent these tragic occurrences. State's attorneys, again, the name is state's attorneys, offices prosecute state criminal crimes. State's attorneys are independently elected and do not answer to county government. In rural counties, the state's attorneys work with municipal police departments or the sheriff's office to investigate and prosecute these crimes. Rural counties don't have their own police departments that they control. Further, the cases are tried in independent state courts.
The judges that preside over the cases and issue the sentences are selected and appointed by the governor and paid by the state. Counties generally have no direct involvement in the criminal justice system, either investigating the crime in the field or trying it in the courtroom. No one is arguing that compensation to wrongfully incarcerated individuals isn't warranted, but making counties responsible for half the cost isn't sensible. County governments have no role in the criminal justice system and can do nothing to prevent future wrongful convictions. Cost sharing should be repealed. Thank you.
Good afternoon, Vice Chair Davis and members of the committee. My name is Weston Young. I'm the Chief Administrative Officer for Worcester County. I'm testifying today on behalf of the Worcester County Commissioners in support of House Bill 1605. Worcester County was also one of the first wrongful conviction cases since counties were put on the hook for 50% of the determined payout. It's worth pointing out again that counties as ours are not involved whatsoever with criminal proceedings. In our specific case, the original claim would cost the county over $2 million for our half of the payout. We've had to put this in our budget, and that is money that will sit there until it's determined if the burden of proof has been met to warrant an award. This earmarked funding diverts from other needs, such as budgeting for our school system, public health, public safety, and so forth. And with any large claim against the county, due diligence requires us to intervene to represent on taxpayers' interests. And an administrative law judge has ruled our intervention appropriate. We're a small county, and our legal department is a one-person shop with limited criminal experience, no offense. So we've had to hire outside counsel. We do not know how many of these cases we may get in a given year. These expenses can be substantial. They are practically impossible to accurately budget for, and they're set without regard to a county's means or ability to afford them. In our example, everything revolves around a case that was vacated due to a state forensics employee who lied about his credentials. And Worcester County is having to potentially pay a significant compensation package due to the actions of a state employee. House Bill 1605 places the moral and financial accountability for rectifying wrongful convictions on the state, where it belongs, and ensures that counties are not penalized for judicial outcomes beyond their control or involvement. I ask for a favorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Cardin.
Thank you, Madam Chair. Thank you all very much for coming. Worcester, we got Hartford County in the House, so very well represented group. So it seems like as the legal officer for Worcester said, that the Office of the State's Attorney is the one who made the mistake. Would that be fair to say?
In the particular case in Worcester County, we believe, as Weston said, it was the state's witness.
The state's witness, okay. The budget for the Office of the State's Attorney comes from the state or comes from the county?
Correct.
Which one?
I'm sorry, from the county, sorry.
From the county, so it's a county agency. So wouldn't it seem as if maybe this is legislation, this is it should be different legislation, but instead of repealing the sharing aspect, which seems to me like you're getting a benefit that half of it's coming from the state versus all of it coming from the county, because it was a mistake made by a county employee. So wouldn't you want to require that this come out of the budget of the state's attorney's office?
Again, it's the state's attorney. We have no control over the state's attorney. They don't report to us, or they hire and fire all their individuals. They make all the decisions on their own. If you
propose legislation to the General Assembly to require the money to come out of the state's attorney's budget, would we be allowed to pass that legislation?
I imagine that you would, yes.
Thank you. Thank you.
And Delegate, I'd like to point out there's a Baltimore County standing by to testify online as well, so.
Oh, great.
In the future panel.
All right, Delegate comments?
I'll just make this briefly, but to your knowledge, the folks at this table here, was anyone notified that the the governor's office, or who originally sets up the budget, that they were going to do this? I mean, was anybody notified? Or, was brought into the discussion?
Not until it was already proposed, and then also it being adopted. Like, we were a part of the conversation, but we were not told that this was going to be happening. But we also have seen in the last year, maybe last 2 years, that these shifts of just state costs, like SDAT or like the operation of SDAT, and teacher pensions, other things that have been state obligations typically are just being shifted to counties, even though we don't have control over them. So this is sort of in that line.
So it's being shifted without even a phone call or a little note saying, hey, you're going to have to carry this load.
I will say that there is, once the proposal is made as part of the budget process, we do end up being a part of the conversation. But as far as why they're considering certain things like that and maybe not considering them or proposing them because of things like what we're bringing up now, that did not happen, no.
Well, I guess where I'm going with this is that the engine, the train engine is on the track and it's moving, and you can't really stop it because that's where they want to go and that's where they go. That's kind of what I'm getting out of this.
Yes, and what I would just add to that is that it doesn't effectively do what they needed to do, which is to balance their budget, because this isn't something that you can book as revenue.
Right.
Effectively, ultimately. So in the fiscal note, I think speaks to that.
I mean, I think this is a good bill. Thank you very much.
Thank you.
So here's what we're going to have to do, members. We have to be back on the floor at 3. And if you look at this pile, this is our vote list, okay? So if you could limit any question you have until one question, or if you could put it in writing and send it to any of the panelists, okay? Are there any other questions? All right. Thank you very much for being here. Thank you. Mr. Bruce Bariano, and is James Benjamin online? Okay. So, Mr. Bariano, whenever you're ready.
Madam Chair, members of the committee, I'll be very brief. Bruce Bariano, I'm here in strong support of this legislation on behalf of Washington County, Queen Anne's County, with the county executive of Wycomico County, and Caroline County. This bill is intended to right a wrong, very seriously. It was done last year to balance the budget in the BRFA, and it's wrong. It's absolutely wrong. Those of you that are lawyers, and even those of you that are on this committee, you know the counties have nothing to do, no discretion, no involvement. The crimes are state-created crimes by the legislature. The state's attorney is separately elected and is not beholden to the county. The county should not be paying for this. It was a cost shift just to balance the budget. And some of you have come from county government. The county government has problems just like you have at the state level, but the laws like the one passed last year aggravate it. Really would urge you to repeal this and right a wrong, or at least phase it in. Or give it, a year for adjustment on both the state and the county end. But it's a shanda. It's a shanda. Thank you.
Next, we'll have Mr. James Benjamin online, please.
Thank you. Good afternoon, Madam Chair, members of the Judiciary Committee. I'm James Benjamin. I'm the county attorney for Baltimore County. I thank you for the opportunity to speak today, and I apologize I was unable to be there in person. Baltimore County does support House Bill 1605. The bill restores a longstanding and appropriate structure where the state fully funds compensation through a state-controlled process. As you all know, the 2025 Budget Reconciliation and Financing Act requires counties in which the wrongful conviction of an individual occurred to fund 50% of the wrongful conviction compensation awards. These cases involve non-county actors. Counties have no role in prosecutions, appeals, exonerations, or compensation decisions. State's attorneys prosecute cases and state officials independent of county governments. Counties have no management oversight authority over those who have these responsibilities, do not participate in eligibility decisions or award determinations. There's no real nexus between the circumstances that lead to these settlement payments and county governments. However, counties currently bear the burden of costs and must now fund half of each wrongful conviction compensation award. And this causes real and ongoing fiscal exposure for counties tied to a state-controlled process. County budgets follow fixed timelines. and county governments cannot plan for costs to fall outside of their authority. So what I started, again, Baltimore County does support this legislation as it restores a longstanding and appropriate structure whereby the state fully funds compensation through a state control process. Thank you very much. Oh, but let me just say this real quickly. We do support, counties do support fair and timely compensation for those who are wrongfully convicted, but funding responsibility should align with the entity that controls the process. And it's the state, not the counties, that control the decisions in this process. And so respectfully, funding responsibility should follow that structure. Thank you.
Are there any questions for this panel? Hold on one second. Are there any questions? Delegate Conaway.
Panel for coming to testify. Does this affect Baltimore City in any kind of way? Potentially?
Yes. Because, correct me if I'm wrong, under the law, a county includes Baltimore City. I think that's in Article 1 of the Constitution.
Right. So how much?
I mean, of the code, excuse me.
How much of this money you think Baltimore City would have to bear? How much additional?
I do not know. Perhaps someone else does. I'm sorry, I do not know.
No? Okay, thank you.
Okay, now we're on the unfavorable panel. Oh, I'm sorry, Delegate Phillips.
A real quick question, because this just seems like a issue of law. Would the counties have standing if in fact that you're going to potentially have to bear the cost of this? Would that then by de facto say, when the case is going on, you have some kind of standing to work to reduce the award? This is just a thought.
To my knowledge, Delegate, I go to all the Board of Public Works meetings, and they're very involved in it, and they handle it. To my knowledge, the ones that have been awarded, and no one's criticizing the awards, they're justified. It's been done at the state level, and I have no knowledge in what I've seen and observed and talked to staff of the Board of Public Works that the counties have been involved at all.
So that's interesting. Okay.
Delegate, after I go, I might be able to answer some of your questions.
Okay.
Because I represent these folks. So.
Thank you.
I don't have you signed up, but go ahead and provide your testimony and your name.
Kristen Mack, so I was favorable with amendments.
Oh, FWA, I was looking at it as unfavorable. Okay.
I know, it's shocking.
Hold on one second. Have we asked all our questions on the favorable panel? All right, so favorable with amendment, Ms. Mack.
Thank you, Madam Chair, Vice Chair, members of the committee. Thank you for allowing me to be here. I'm Kristen Mack. I'm a civil rights attorney, and I actually represent exonerees that are trying to get Walter Lomax's petition granted and all of that. I know I threw you off because you probably didn't expect me to be here for a MAKO bill, but there's a first time for everything. So, but that goes to show how important this issue is that I'm here to highlight today. And I want to be very clear. I take no position on who should bear the burden of the compensation. It's outside my lane. I have no opinion whatsoever. I am here just to be sure that the statute remains coherent and that it's workable for exonerees. When the General Assembly passed the Walter Lomax in 2021, you built a very good system. It's not perfect. I have my problems with it, but it's workable the way it's been for the past 4 or 5 years. All things innocence have always been handled by the state's attorney's office. All things compensation and benefits has always been handled by the state through the Attorney General's office, and it has worked. By making the counties pay 50%, it has led to them trying to intervene in these actions. So far, they have been successful. It's being challenged in circuit court right now because I disagree. I think it's very clear the legislator did not want them to be parties. But because they have a financial interest, it's basically like they're an insurance company trying to protect their pockets. I'm not knocking them for it because I understand they have a job to do. But this has impacted the way that this works in practicality. By them coming in, because again, they have the same interest as the state, the financial interest. But the state has never opined about innocence one way or the other. They've come in, they're going, they're contesting innocence, even though the state's attorney in Worcester County has said there's no evidence to support us doing anything further on the criminal side. They're not having an opinion. They've asked the ALJ to let them out of the proceeding altogether. And so I'm just afraid of what it's going to turn the Walter Lomax Act into if we allow counties to be parties when all they have is a financial interest, but they're allowed to contest innocence as well. You know, outside law firms coming in and doing this, you know, they have all the resources and everything, and the standard's already difficult enough. There's only been about 15 of these granted in ever since the Walter Lomax has passed. So I'm very fearful of what this will look like in the future.
Okay, thank you very much.
Thank you.
Are there any questions? Thank you very much, Ms. Mack. And thank you to the bill sponsor for bringing the bill. That is our last panel, and that is our final bill, final House bill for year 2026 session. Thank you. All righty. We're going to go into our vote session in just a few minutes. I can only say at best 3 to 5 minutes, folks, okay? And we're going to start our, we'll start our vote session. The speaker has asked us to be back promptly at 3 o'clock.